of fraternity. The order is also not very great at all. However, I'll just, since many questions are being raised and many things are being discussed, I will explain everything to the best of my ability. Article 32 of the Constitution empowers every citizen of India to approach the Honorable Supreme Court directly in case of violation of any of the fundamental rights. अगर इस केस में ऑनरेबल सुप्रीम कोर्ट के पास जुरिस्डिक्शन नहीं है, ओरिजिनल जुरिस्डिक्शन, तो मुझे नहीं लगता कि सुप्रीम कोर्ट के पास किसी भी केस में ओरिजिनल जुरिस्डिक्शन बनती होगी. आई हैव नेवर हर्ड ऑफ एनी केस मोर मेरिटोरियस दैन दिस आर केस, where some 10 to 15,000 commissioned officers of the Indian armed forces are affected. Their fundamental rights are being violated. It is very clear that their fundamental rights are being violated, and still they cannot approach the Supreme Court. They will have to first go to High Court, waste their time, 2, 3 years, 5 years, whatever time the High Court takes, and then go to the Supreme Court. It is just a waste of time. Why it is a waste of time? Because we know for sure that the case is going to go to the Supreme Court. See, theoretically, we can go to High Court, we win the case from the High Court, and the government will not appeal in the Supreme Court. That is never going to happen. Any idiot knows that. बच्चे को पता है कि अगर हम केस जीतते हैं तो सरकार हमारे खिलाफ अपील करेगी ही करेगी अल्टीमेटली, या अगर हम केस हारते हैं तो हम अपील करेंगे. अल्टीमेटली जब डिसीजन जो कि इम्प्लीमेंट किया जा सकता है, व्हेन द डिसीजन इज गोइंग टू बी पास्ड बाय द ऑनरेबल सुप्रीम कोर्ट इटसेल्फ, then why waste time of the High Court litigating in the High Court for whatever number of months or years? Because ultimately the whatever decision can be implemented will come from the Supreme Court. बबीता पुनिया केस जो हुआ लेडीज के लिए परमानेंट कमीशन वाला, women officers के लिए, 2003 it was filed in the High Court, 2010 it was decided by the High Court, appealed in the Supreme Court, 2020 the decision came from Supreme Court. So 7 years in the High Court was actually a waste of time, no? Because let us say in 2003 it had been filed in the Supreme Court and the decision was given by the Supreme Court in 10 years, so 2013 the decision would have come. सुप्रीम कोर्ट को वो सारा ग्राउंड वर्क, पेड वर्क दोबारा से करना पड़ेगा. येस, इट इज पॉसिबल दैट अ फ्यू फैक्ट्स और सम काइंड ऑफ अ लीगल पोजीशन हैज बीन असर्टेन्ड एंड ऑलरेडी थॉरली ड्वेल्ड अपॉन बाय द हाई कोर्ट, एंड वो थोड़ा सा काम सुप्रीम कोर्ट का शायद बच जाए, बट मे बी नॉट इवन 10% ऑफ द टाइम विच द सुप्रीम कोर्ट विल बी टेकिंग कैन बी सेव्ड बिकॉज वी आर गोइंग टू द हाई कोर्ट फर्स्ट. Article 32 of the Constitution of India reads like this: the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by Part 3 of the Constitution of India, that is fundamental rights, is guaranteed. अब मैं आगे का थोड़ा एक्सप्लेनेशन जो इंडियन कानून से में है वो मैं पढ़ रहा हूँ. Article 32 of the Indian Constitution is a fundamental right that guarantees the right to constitutional remedies. It is considered one of the most crucial provisions in the Constitution as it empowers individuals to seek protection and enforcement of their fundamental rights directly from the Supreme Court of India. Article 32 grants every individual the right to move the Supreme Court for the enforcement of their fundamental rights. This means that if someone believes their fundamental rights have been violated, they can approach the Supreme Court directly for relief. It also ensures that not only do individuals have the right to move the Supreme Court, but the court also has the power to issue appropriate writs, appropriate orders, directions for the enforcement of fundamental rights. तो जो हमने सुप्रीम कोर्ट में केस डाला था, वी हैड बीन आस्किंग फॉर अ रिट ऑफ मैंडेमस. रिट ऑफ मैंडेमस होता है टू कंपेल अ पब्लिक अथॉरिटी टू डू समथिंग विच दे आर बाउंड टू डू, और टू स्टॉप डूइंग समथिंग और अवॉइड डूइंग समथिंग विच दे आर नॉट एंटाइटल्ड टू डू. मैंडेमस टू डायरेक्ट अ पब्लिक ऑफिशियल और अथॉरिटी टू परफॉर्म अ ड्यूटी they are legally bound to perform. So we were saying in this case that the government of India or the Ministry of Defense or the Ministry of Finance is legally bound to give equality to short service commission officers by way of grant of NPS or CPF, and that is why we had moved the Honorable Supreme Court directly for grant of these benefits or equality. High Court also has jurisdiction in this case under Article 226 of the Constitution of India. So Article 226 is like this: notwithstanding anything in Article 32, every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, within whose within those territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, for the enforcement of any rights conferred by fundamental rights. हाई कोर्ट भी मैंडेमस इशू कर सकता है गवर्नमेंट को इस सेम केस के लिए. हाई कोर्ट ऑल्सो वेरी मच हैज द jurisdiction in this case. However, so since High Court and Supreme Court both have jurisdiction, I think majority of the officers in the beginning, when this case was being planned and at the inception of this case, when we started doing the groundwork in August 23, we conducted polls on our WhatsApp groups at least twice to see how many officers or which all officers wanted to go to High Court and which officers wanted to go to Supreme Court. And in an overwhelming majority, the officers asked for going to the Supreme Court. Probably the reason for this is that no one wants to wait for 5, 10, 15 years to be granted a benefit or equality which they rightfully deserve. Obviously हमें पता है कि हमें NPS मिलना चाहिए या CPF मिलना चाहिए, हमें बाकी गवर्नमेंट सर्वेंट से इक्वालिटी मिलनी चाहिए. So everyone wanted a quicker decision, and that is why it was decided that we'll be going to the Supreme Court. It is unfortunate that, see, once the Honorable Supreme Court with CJI himself, that is then CJI Justice Chandrachud, with the bench of 2 more judges, once they had issued notice to the government, not just in this SSCO's NPS case but also in MNS officers NPS case, उन्होंने 2 बार गवर्नमेंट को नोटिस दिया है सिमिलर केसेस में. तो गवर्नमेंट then at this point of time, this issue of jurisdiction should not have arisen, and the Supreme Court should not have asked us to approach any other alternative appropriate forum. As regards the AFT is concerned, AFT की jurisdiction section 14 में defined है. I will read out section 14 clause 1 now. Save as otherwise expressly provided in this act, the tribunal, that is the AFT, shall exercise all the jurisdiction, powers and authority exercisable immediately before a particular date by all courts except the Supreme Court or a High Court exercising jurisdiction under Articles 226 and 227 of the Constitution in relation to all service matters. See, Article 226 relates to enforcement of fundamental rights by orders of High Court by grant of a particular writ. ये हमारा एक writ है, हम इसमें mandamus मांग रहे हैं High Court से या Supreme Court से. We are saying that please enforce our right to equality. So, but ये जो jurisdiction है ये AFT के पास नहीं है. AFT cannot, does not have the powers of a writ jurisdiction. जो power High Court enjoy करता है under Article 226, वो powers AFT के पास नहीं है. Moreover, service matters. Service matter is defined under section 3O. Service matters means in relation to persons subject to the Army Act, Navy Act, Air Force Act, shall mean all matters relating to the conditions of their service. So conditions of their service, see, it is हमारा जो case है ना, we are not filing this case because we are military people, because we are in the defense forces. हमारा case ये है कि हमें, we are government servants, so we should be placed on par with all government servants. This government servant may, as I've been saying repeatedly, he may be an IAS officer, he may be in some government school, in some government college, hospital, any other government department, he may be in some PSU or in some autonomous body under some central government ministry. हम अपने आप को उनसे कंपेयर कर रहे हैं. हम ये नहीं कह रहे हैं कि because I am a फौजी give me NPS, because I am a फौजी give me CPF. No, we are saying that because I am a government servant, give me NPS. Because I am a government servant, because I am a central government servant, तो हमें इसे मिलना चाहिए. So जो military service का इसमें बात ही नहीं आ रहा. It is not about service conditions. It is not a violation of my service condition that I am not being granted NPS. It is
see whether we go to the AFT or to the High Court. My opinion is certainly High Court. Wherever we go, the government will oppose. We go to the High Court, they will say that no, they should have gone to the AFT. We go to the AFT, they will say no, they should have gone to the High Court, because the jurisdiction lies in some other forum other than the forum in which the petitioners have come. See, obviously the government will try to delay us as much as possible. When you don't have a defense, you delay the other party. They have lawyers. लॉयर्स का काम है कहना, कुछ तो लॉयर्स कहेंगे. ओके, एनी लॉयर विल से दैट दिस इज नॉट ब्लैक कलर, दिस इज ब्लू, दिस इज रेड. वॉट एवर आई से, he will counter that. Whether they have a counter or not, they will just try their best. They have misled the Honorable Supreme Court in this case by saying that, that similar pension matters are pending in the High Court. That is what they said in the Supreme Court yesterday. There are no similar pension matters pending in the High Court. This, our case for NPS is not a pension matter. It is not that proper pension which जो एक आम व्यक्ति समझता है पेंशन से. दिस इज नॉट दैट टाइप ऑफ पेंशन. दिस इज एनपीएस. दिस इज जस्ट अ मंथली emoluments. This is national pension scheme, but it is not that pension what a normal person understands by pension. There is no case pending of a similar nature in the Honorable Delhi High Court pertaining to pension. Delhi High Court में obviously pro rata pension cases are pending. So, but just because the court was already kind of pre-decided, or they were already predetermined that we have to send this matter to either AFT or High Court. So they just tried to confuse the court and they succeeded in it. वो पेंशन का कुछ भी ऑर्डर उन्होंने दिखा दिया और ये कह दिया कि पेंशन मैटर ऑलरेडी दिल्ली हाई कोर्ट में पेंडिंग है. इज़ नॉट प्राइमरीली अ पेंशन केस. इट इज़ प्राइमरली अ केस फॉर राइट टू इक्वालिटी. हमने बार बार अपने पिटिशन में वी हैव रिपीटेड इट 100 times. I am also a government servant. Everyone else who is a government servant is getting NPS. All civilians are getting NPS. Those who are Fauji's, that is, they are also government servants. They are getting some other form of pension, that is old pension scheme. Some other people are getting both. Some other people are getting NPS plus CPF, that is Contributory Provident Fund. I am also a government servant. Please give me NPS. This is my argument is based on my right to equality, which is enshrined under Article 14 of the Constitution of India and which can be enforced either by Article 32 of the Constitution by going to the Supreme Court or by Article 226 by going to any High Court. No, that it is for the fundamental rights that the Constitution was created and not the other way around. Fundamental rights are not there because the Constitution exists. It is for the embodiment of the fundamental rights that a constitution has been created. That is, you research and you will find that fundamental rights is the most sacred and sacrosanct part. Has commented that the petition was too long, it should have been more concise, and there was a lot of unnecessary jargon. I don't really think there was anything unnecessary. Moreover, before getting the case filed, we started working on this petition in August 23 and we kept working on it till the very last, that is till April 24. And between these 7-8 months, the petition was shared on the group multiple times, and comments and criticism and suggestions, advices were invited from everyone. Many people gave their comments and suggestions. Some of those were incorporated, whatever was found to be relevant. Some of it was left out. Tons of research was carried out, and the petition was shared on the group many times, and to individuals also, whoever asked for it. And only after that the petition was finalized. Many people who have been asking the copy of the petition, I have shared either individually or on groups. So any suggestions which were there could have been taken care of before the case was filed. And now when we'll be going to the High Court, so again we'll be discussing and whatever your inputs are, anyone's inputs can be discussed. One issue which I would like to state is, what is the duty of any officer, any short service officer or a permanent commission officer or any individual? This has been in debate and discussion for thousands of years in India alone. जब कोई व्यक्ति धर्म संकट में पड़ता है, मुझे लोग जैसे अनफॉर्चुनेटली कुछ जैग ऑफिसर्स मिलते हैं, वो बोलते हैं कि यार भाई तू ये क्या कर रहा है, या सर मैं इस केस में क्या, मुझे तो डिफेंड करना ही पड़ेगा, मैं क्या कर सकता हूँ, मैं तो एक प्यादा हूँ. आप अगर एक प्यादे हो और अगर आपको कह दिया जाए कि सामने जितने लोग खड़े हैं सबको गोली मार दो, तो क्या आप मार दोगे? You know what is happening is wrong. There is not an iota of doubt possible. 2 करोड़ लोगों को जो चीज़ मिल रही है वो सिर्फ आर्मी, नेवी, एयरफोर्स को नहीं मिल रही. Only short service commissioned officers are being deprived. Don't you know what is right and what is wrong? Your duty in such situations is to resist. Okay? It may not be very great for your career. Things may not be very great for you individually. Your bosses may not be happy. But what you are doing is you are giving धोखा to your soul. You are giving धोखा to your community. आप अधर्म का साथ दे रहे हैं. ये जो पूरी महाभारत में, रामायण में इसके बहुत इलस्ट्रेशंस हैं. इसमें भी इसका बहुत बड़ा एग्जाम्पल है. जनरल डायर ने जलियांवाला बाग मैसेकर में काफ़ी सारे अपनी फ़ौज को कहा कि भाई ये निहत्थे लोग हैं, इन्होंने एक whatever it is, you just fire at them, kill all these bloody Indians, all these dogs and Indians need to die. And those people who were firing were also Indians, many of them, or maybe most of them, or all of them. और उन्होंने अंधाधुंध गोलियां चला दी जब तक उनकी गोलियां नहीं खत्म हुई. सो थाउजेंड्स ऑफ पीपल डाइड इन जलियांवाला बाग मैसेकर. ऑब्वियसली गवर्नमेंट फिगर्स आर डिफरेंट. तो उस समय आप ये कहोगे कि साहब मैं क्या कर सकता हूँ, मैं तो सिर्फ एक सिपाही हूँ साहब, मेरे को तो आदेश मिला है, मेरे को तो गोली चलानी पड़ेगी. नो, दैट इज नॉट व्हाट यू शुड बी डूइंग. यू शुड बी रेजिस्टिंग सच एन ऑर्डर. इनफैक्ट यू कैन नॉट जस्ट बी ए म्यूट स्पेक्टेटर. यू कैन नॉट से सर मैं क्या कर सकता हूँ. एटलीस्ट डोंट कोऑपरेट विद द इविल. ऑल दैट इज रिक्वायर्ड फॉर इविल टू सक्सीड इज दैट गुड मैन डू नथिंग, बट यू आर कोऑपरेटिंग विद देम ऑल्सो. नो, यू आर सेइंग सर मैं क्या कर सकता हूँ, मैं क्या कर सकता हूँ का ये मतलब है आप अपने ही भाई बंधुओं को आगे केस हरवाओगे. यू शुड नॉट. Many of these cases unfortunately are being ruined, are being spoilt by our own fraternity. So there are so many examples. You cannot just say मैं क्या कर सकता हूँ. दुर्योधन ने कर्ण को he just gave him recognition. He did not recognize him as Sutputra, and he made him Angraj, the king of one particular place. And just because that happened, this Karn thought that for his entire life and maybe for eternity he is indebted to Duryodhan. दुर्योधन ने उसे अपने फ़ायदे के लिए वो recognition दिया, या मे बी 10-20% अपने फ़ायदे के लिए, मोस्टली उसका मेरिट होगा भले ही. बट there was a tinge of selfishness in the recognition which Duryodhan gave to Karn. जो हम वी आर डूइंग देश सेवा, वी आर वर्किंग फॉर द गवर्नमेंट, द इंडियन आर्मी, नेवी, एयरफोर्स, वी आर सैक्रिफाइसिंग एंड कॉम्प्रोमाइजिंग आवर लाइव्स, बट इट इज़ नॉट एज इफ द गवर्नमेंट इज डूइंग एनी फेवर टू अस. विद ऑल ड्यू रिगार्ड टू एवरीवन कंसर्न, वो हम पे कोई एहसान नहीं करी है हमें नौकरी दे करके. हम उनके बंधुआ मजदूर नहीं बन गए हैं. हमें सही और गलत में भेद करना पड़ेगा. हम ये नहीं कह सकते कि सरकार ने मुझे नौकरी दी, मुझे बहुत बढ़िया तनख्वाह मिल रही है, सो आई विल जस्ट डू वट एवर इज़ द ऑर्डर पास टू मी. I will just write whatever my senior wants me to write. I will simply, side with the government, and I will laugh, I will mock at people who are fighting for justice. This is not your duty. ये आपका धर्म नहीं है. हाँ, ये कुंभकर्ण, he says कि रावण मेरे भैया हैं, रावण भैया मेरे भगवान हैं, मेरे ईश्वर हैं, जैसा भी वो कहेंगे मैं वो करूँगा. मुझे पता है कि जो मैं कर रहा हूँ वो गलत है, लेकिन मैं फिर भी वही करूँगा. मुझे नहीं पता, क्योंकि मैं तो बस, मेरे तो भगवान, मेरे भैया ने मुझे वही आदेश दिया. अरे आप अपना दिमाग का इस्तेमाल करो. आप फैक्चुअली देख लो. मैं कह रहा हूँ 1.5 से 2 करोड़ लोगों को इंडिया में, जो भी गवर्नमेंट सर्वेंट्स हैं, स्टेट गवर्नमेंट, सेंट्रल गवर्नमेंट, सारे PSUs, सारे ऑटोनमस बॉडीज, जो भी आपको लगता है कि वो गवर्नमेंट सर्वेंट है, उस बंदे को सरकार की तरफ से NPS में कॉन्ट्रीब्यूशन मिल रहा है, या कॉन्ट्रीब्यूटरी प्रोविडेंट फंड मिल रहा है. भले ही वो 1 साल नौकरी करे, 2 साल करे, 5 साल करे, या 50 साल करे. इंडियन कोस्ट गार्ड में भी सबको NPS मिल रहा है. ओनली आर्मी, नेवी, एयरफोर्स, शॉर्ट सर्विस कमीशन ऑफिसर्स आर लेफ्ट आउट. इज दिस नॉट ग्रोस इनजस्टिस? यू आस्क एनी 10-year-old चाइल्ड. 12 साल की उम्र में बच्चा सिविक्स में पढ़ लेता है, राइट टू इक्वालिटी. आप किसी बच्चे से पूछ के देख लो, अगर वो बच्चा आपको बता दे कि ये अन्याय नहीं है, तो आई विल विड्रॉ दिस केस. ठीक है, बट अब इसको जस्टिफाई, देयर कैन बी मेनी आर्ग्यूमेंट्स. नो, एज आई बीन सेइंग, लॉयर्स आर देयर, दे विल आर्ग्यू. दे हैव ASGs, additional solicitor generals of India, they have solicitor general, they have so many big heavyweight champions who are lawyers. They will argue something. They will argue सुप्रीम कोर्ट में डाले तो इसे सर हाई कोर्ट में जाना चाहिए, हाई कोर्ट में डाले तो सर इसे AFT में जाना चाहिए, AFT में डालेंगे वो कहेंगे हाई कोर्ट में डालना चाहिए, बिकॉज दे जस्ट वांट टू डू पिंग पोंग. एक न्यूज़ भी आई थी, अखबार में छपी थी, दैट दिल्ली हाई कोर्ट इज सेइंग दैट आर्मी पीपल शुड नॉट बी मेड पिंग पोंग ऑफ. इनको एक कोर्ट से दूसरे कोर्ट में नहीं भेजना चाहिए. बट these people, they are so depraved, so deprived of any sense of conscience and morality, that they are just completely indifferent to our pains and sufferings. I may not be starving to death, I may be from a well-to-do family, but that does not mean that my right to equality is not important. Actually problem ये है इसमें कि जुडिशरी भी, या सारे important जो IAS officers or politicians or bureaucrats, no one knows that short service commission officers are not getting any form of social security scheme, no pension, no pro rata pension, no NPS, no anything. तो वो कोई ना इस चीज़ को easily believe नहीं कर पाता है. So they have and they feel that these are rich people, they are powerful people, and officers are there just to enjoy lives. So we don't have that sympathy from the public and especially from the powerful people. We need to get sympathy from the public, not because we are starving or anything else. We are doing fine. You know, short service officers, even outside, after going out of the army, we are not super elite or super successful, but we are at least not starving, you know, certainly above middle class or maybe upper middle class. But that does not mean that the right to equality can be compromised. आपको अगर नहीं देना है ना हमें NPS या CPF या UPS, मत दो. मैं कह रहा हूँ देश के जो 2 करोड़ लोगों को जो मिल रहा है ना उनका भी खत्म कर दो. Finish it from them, bring me on equality, bring me on par. जिस भी तरीके से इक्वालिटी हो सकती है ना, जो मुझे मिल रहा है वही उसे मिलना चाहिए, जो उसे मिल रहा है वो मुझे मिलना चाहिए. अगर सर हम तो प्यादे हैं, सर हम क्या कर सकते हैं, what can I do about it? I have been instructed from above, I have been instructed by my senior officers. See, your duty is to resist this kind of illegal orders. These are people who have been themselves, you know, their seniority has been depressed for the last 40 years by 2.5 years. All JAG officers suffer this depression of seniority by 2.5 years, but they are not able to protest. They are not able to say to anyone that why is this injustice being meted out to this department alone. I have filed a writ petition in the Delhi High Court against this, but that also is being resisted by them. They are hell-bent upon getting their own seniority depressed. Ye log, they are always against you. They will say, whichever court you go to Supreme Court, they will say go to High Court. You go to High Court, they say you have to go to AFT, because they want maximum time waste हो जाए. You bleed the veteran dry. वो इतना उसे तड़पाओ तरसाओ, 5-7 साल हो इधर कोर्ट में धक्के खाए, अलग अलग कोर्ट्स में जाए, his morale should go low, you know, their confidence should go low, they should be deprived of all the resources. This is the endeavor of the department. That is what I am saying, that your duty is not just to comply with whatever illegal order is passed to you. Your duty is to resist illegal orders. Your duty is to stand up for what is right. You have a conscience, you have a soul, you have a common sense. You know that what is happening is unjust. You know that only one department, only one segment of people are being deprived. It is clear-cut violation of right to equality. You should stand up for what is right.